अगर अभी के लिए मैंने चावल बोला अभी नरम में अच्छा है, तो अगर इसकी मखनी करना है तो फिर हम कल करेंगे, कल के लिए बचेगा। ठीक है, मैं अभी आधा चम्मच से मेरी चावल भी लेकर आई थी, दूधी का 1 चम्मच लेकर आई इसके साथ। तो पहले पानी का था, तो ये पूरा सुबह खा लिया। तो वही ना, बहू का अगर अच्छा साफ पानी है तो फिर मत कर, फिर बॉटल में डाल के रख।
Good evening, ma'am. Ma'am, shall we start? Ma'am, shall we start? Ma'am, shall we start the meeting?
Yes.
Greetings, everyone. This is Rajans, an executive member under Legal Vidya. Welcome you all to the fifth class of our AIBE 10 days crash course organized by Legal Vidya. So, without any further ado, let's warmly welcome our esteemed speaker, Advocate Nivedita Kondinya, ma'am, to the virtual stage. Over to you, ma'am.
Thank you, Rajhans. Good evening, everyone. Good evening, all the participants. And in today's class, we are going to deal with Transfer of Property Act. Okay. So in today's class, we are going to discuss Transfer of Property Act. We will discuss important topics related to it, and then we will navigate our Bear Act to look into some important topics. So let me share my screen. Can you see my screen now?
No, मैम आपकी स्क्रीन शेयर नहीं हो रही है.
Okay. Okay. Now it's visible, right?
Yes, ma'am.
Okay. So let's begin with today's session. So, Transfer of Property Act. It is one of the more important topics from AIB syllabus, and you will find questions from Contract Act, Transfer of Property, and Negotiable Instrument Act, and they will be in proportion 4:4, or maybe four questions from contract and three questions from transfer of property, and one from negotiable instrument. So basically, from Transfer of Property Act, you will find three to four questions at max, and they are mostly related to some basic principles and the basics of TPA, right? So we will not be discussing any case laws from this particular portion or the subject, because case laws are not asked in this examination from TPA portion. Also, some major sections which are always asked in examination, I have mentioned here, and only studying these sections would be sufficient for the purpose of this examination. I have also listed some important questions here in this document, and we will be discussing all those questions and answers, and how to find those answers and where to find it. So, without any further delay, let's begin with the class. So, first of all, I have mentioned some important legal doctrines from TPA, or some important topics which could be found in TPA, but it is not expressly mentioned in the Bear Act. So you will be you may face problem regarding that. So the first one is spes successionis. It is spes successionis, and it is a Latin phrase which means that the expectation of an heir apparent to inherit someone's property. Okay, and in India, under the Transfer of Property Act, Section 6A of the Transfer of Property Act prohibits the transfer of spes successionis. Okay, and spes successionis is a principle which is based on sorry, it is based on the principle that a living person has no heirs. Okay, so you could be someone's heir only after that person is no more. Okay, it's dead. So a living person could not have an heir. Only there may be possible heirs to that person, and only after the person dies the legal heirs uh, come into existence. Okay, so section 6A of the TPA says that a transfer of property could not be made to a spes successionist. That means before a person whose property is there, its property cannot be inherited till the time when he is living by his legal heirs. Okay. This includes the chance of an heir apparent succeeding to an estate, the chance of a relation obtaining a legacy on the death of a kinsman, and any other similar possibility. So, space successionist includes any direct legal heir upon a estate who will be succeeding the deceased person. It also deals with the chance of any relation which is there, which could be a heir after the death of that kinsman, and any other similar nature of possibility. And TPA section 6A prohibits this kind of transfer. Okay, so you have to remember that spes succession is not a kind of transfer which is allowed by the Transfer of Property Act. Coming on to the next important topic, it is doctrine of election. So, as per doctrine of election, it is a legal principle which requires a person to choose between two conflicting rights or benefits. Okay, and it is the doctrine of election says that if a person chooses something, so he has to choose both the advantages as well as the disadvantages. No one could take benefit from something, and after that he will not own the disadvantages of it. Okay, so if say suppose there is some property, okay, and there are certain rights which are to be enjoyed by the person who buys that property, but at the same time there are certain duties, liabilities which has to be paid upon after by the person who owns that property. So you, being that person, you purchase that property. So you cannot say that I will enjoy all the rights of the property, but I will not pay any liability, whichever it is occurring from it. Okay. So you have to be in position to accept both the rights and liabilities, and this is the doctrine of election. Coming on to the next topic, it is nemo dat quod non habet. It is a legal maxim which says that it is provided in the section 41 of the act, and it is an exception to the general principle of transfer of property, where a person cannot transfer a superior title to the property than what they hold. Okay, so general principle of transfer of property says that any person cannot transfer a superior title to the property than what he holds. So someone, if someone is holding only tenancy rights to a property, they cannot transfer the ownership of the property, because they are not the owner of the property, they are only in possession of it. So they can only transfer the possession, they cannot transfer the ownership. So this is the general rule. Coming on to rule against perpetuity. So this rule states that a gift made to an unborn person is void. Okay. However, this rule does not apply if the person transfer a property to a trust for the benefit of their unborn grandchildren. So usually a direct transfer to an unborn person is void as per the rule against perpetuity. However, anyone could transfer their property to a trust, okay, and that would be used for benefit of their unborn grandchildren, but it cannot be directly transferred to their unborn grandchildren. Then we have doctrine of lis pendens, which is recognized under section 52 of the Act. It is also a Latin phrase, and it states that any transfer of immovable property during a legal suit that involves the property is subject to the outcome of the suit. Okay. Basically, it means that at the time when when a legal suit is already in proceeding, it has not been disposed of, then if any transfer has been made of some immovable property, then the transfer would be only the transfer will depend upon what is the outcome of that legal suit. So transfer will not be effective till the time the suit has been disposed of, or it has been or some decree has been passed to the suit. Okay. So any transfer, when it is dependent on the outcome of the legal suit, then their doctrine of lis pendens applies. Now let's discuss the important principles, important legal terms related to transfer of property, which are mentioned on the different sections which have been enumerated here. Okay. Till here, do you have any questions? Okay. I suppose there are no questions till here. So let's move forward to the our act. Today, are you guys having your bear acts with you? Participants, are you having your bear acts with you? Okay, then let me open it in my and share my screen.
Ma'am, I think you are muted.
Oh, sorry. Can you see the bear act?
Yes, ma'am.
Okay. Okay, so first of all, the important topic from the Bear Act itself is the date of enactment, okay, which is 17th of February 1882. Then the preamble, which states that whereas it is expedient to define, amend certain parts of the law relating to the transfer of property by the act of parties, okay. Then move forward to chapter 1. First of all, there is this commencement clause. So there are certain acts which have the commencement clause. There are certain acts where it is said that the act will come into existence when it is announced in the official gazette by the government. Okay. So this is the act where commencement clause has already been provided, and it states that it shall come into force on first day of July 1882. So, whenever there is a question that on which date TPA came into existence, then it is the date of 1st July 1882. Okay. Then, moving forward to the interpretation clause. Now, here under interpretation clause, there are a number of definitions, but most important of them are number one, immovable property. And according to Transfer of Property Act, immovable property does not include. So this is a definition which is of negative nature. It tells you what is not included in the definition of immovable property. Okay, it does not tell you what is a immovable property, but it tells you that what not is an immovable property. So apart from whatever has been mentioned here or whatever has been listed here in this clause, all the properties will be immovable property. And what is not included is the standing timber, growing crops, or grass. Okay. Then next definition is of instrument. Instrument means a non-testamentary instrument. So basically, instrument here under Transfer of Property Act will not include a will which is made or executed by a person. Okay. Non-testamentary instrument means an instrument which is not a will. Other than all the will, every instrument will be falling under this definition. Then the next important definition is of attached to earth. So transfer of property defines or lays down the properties which will be considered as attached to earth. They are not immovable properties, they are not movable properties, but they are attached to the earth properties. And what are those? Properties which are rooted in earth. For example, in case of trees and shrubs. So trees or shrubs will be, since they are rooted in the earth, they cannot be transferred without damaging their nature. Okay. Therefore, they are the properties which are attached to the earth. Then embedded in earth, as in case of walls and buildings. So you cannot transfer a wall or you cannot transfer a building, even though it is not originally the ground, but it is also embedded in earth. It is not somehow that you will just pick up the house and you will transfer it somewhere. Okay. And then thirdly, attached to what is so embedded for the permanent beneficial enjoyment of that to which it is attached. So you have to focus on this expression, the permanent beneficial enjoyment. Okay. So first is rooted in earth, second is embedded in earth, and third is attached to what is so embedded for the permanent beneficial enjoyment. So whatever properties are embedded in earth, as in case of walls or buildings, so if something is attached to the wall or something is attached to the building in such a manner that it is for the permanent beneficial enjoyment of that wall or building, then it will also be called as attached to earth. Okay. So since doors are there, windows are there, and they are movable properties. But once a door is attached to a building, once it is attached to a wall, once a window is fixed to the wall, then it will be called falling under third category of attached to the earth, because it is attached with the thing which is embedded in earth, that is the wall or building, and it is for the permanent beneficial enjoyment of that building. Okay. So things like doors or windows or say ceiling. So all these things are things which are attached to what is embedded, what is so embedded for the permanent beneficial enjoyment of that. Okay. And these will be called as the things which are attached to earth. So in the further sections, we will find that things which are attached to earth can also be transferred under the TPA. Why? TPA deals with the transfer of immovable property. Okay. And transfer of movable property is dealt under, it is dealt under other acts. For example, Sale of Goods Act. Okay. Coming on to next important topic, actionable claims. So actionable claims means a claim to any debt other than the debt secured by mortgage of immovable property or by hypothecation of or pledge of movable property or to any beneficial interest in movable property not in possession, either actual or constructive, of the claimant, which the civil courts recognize as affordable ground for relief, whether such debt or beneficial interest is existent, occurring, conditional, or contingent. Okay. So basically, actionable claims will be any claim to any debt other than all the debts which are related to these listed properties. Okay. And actionable claims are transferable property. So you have to remember these two things which are not mentioned here directly, but they are mentioned indirectly and in other further sections also. So actionable claims and things which are attached to earth, they are considered as immovable property which can be transferred under the transfer of by the provisions of Transfer of Property Act. Coming on to the transfer of property by act of parties. And here, the definition of transfer of property has been provided under Section 5. So, according to Section 5, a transfer of property means number one, an act. Okay. So, first essential of transfer of property is an act. And what kind of act? By which a living person conveys property. Okay. So, there should be an act, there should be living persons, and there should be conveyance of property. And this property could be conveyed in present or in future. Okay. So, there should be a future transfer also, and there should be a present transfer also. It should not be in past tense. So, you cannot say, suppose person A has already transferred his property to someone, and afterwards he transfers that, because what has already been transferred cannot be transferred again, right? So transfer of property could not be in past, it has to be either in present or it should be in future. Okay. And how it is conveyed? To one or more other living persons. So a living person is should be there to transfer a property, and then he or she should transfer that property to other one or more living persons. Okay. Or to himself. So a transfer of property could also be made to himself. Okay. And one or more other living persons. And okay, sorry. So this expression means that a property could be transferred in such a way that it it is transferred to one or more other living persons, or it could be transferred in such a manner that it is transferred to the same person who is transferring. Okay. Or in third situation, it could be transferred to someone more than the person, to the person who is transferring, additionally to other persons. Okay. So there could be three situations. Then let's come to uh, and to transfer property is to perform such act. So basically, to transfer a property means that one living person conveys conveys a property. Now here there is no mention of his property, right? So it is not necessary that the property which is being transferred should be the property of the person who is transferring it. Okay. I will also show you one question regarding this. So the person who is the transferer should not be the owner of the property. It is not essentially required that he should be the owner of the property. He could be the owner of property, but it is not always necessary that he should be the owner of the property. Is it clear? Can you understand this point? Okay, let me repeat it. Let me give you an example. So there is a person who is an agent of some other person. Okay. And that agent is transferring a property to some other person, and the property which he is transferring is not belonging to him, but it is a property of the person who is the principal of that agent. Okay. But on the permission of the principal, the agent is transferring the property to person C. Okay. So in this situation, agent is a living person who is conveying a property in the present time to one other living person who is person C. Okay. So he is making a transfer of property. So here, can you say that the property should be of agent? No, right? So it is not necessary that the property which is being transferred should be of the person who is transferring the property. That person could be duly authorized person to transfer that property, and it is not necessary that he should be the owner of that property which is being transferred. Am I clear till this point? Participants, you may raise your hand if you are not understanding. You may ask again and again, but please reply if I am I making any sense till here? Okay, so what should I suppose, that it is not at all clear, or is it everything is clear till now?
Little much clear, ma'am.
Okay, so it is little bit clear. What you could not understand, Julie?
Whole topic, ma'am. Today's
The
whole topic.
transfer of property topic.
Yes, ma'am.
Okay, okay. Okay, so basically, let me break whatever I am stating. Okay, so I was telling you what means a transfer of property. Okay, so transfer of property means, number one, let me tell you the essentials of it. So there has to be a living person, right? It is clear. This person will transfer a property. Okay, this transfer of a property has to be in present or in future. Thirdly, to whom it will be transferred? To one or more other living persons. Basically, remember, two other living person, who could be more than one also. Okay. Also, the person could transfer the property to himself also. Okay. So, after these five essentials, a property could be transferred. Or you can say that there are five elements to make a transfer of property effective. Now, what I was trying to convey you all is, the property which is being transferred is not necessary that it should be owned by the person who is making the transfer. Okay, so this property, wait a second. So this property could either be owned by the person who is transferring, or the person could be either legally authorized to do so. Okay, the person who is legally authorized to do so can be the person who, say suppose, is the agent of the owner of the property. Okay, is it clear now? Julie, is it clear to you now?
Yes, ma'am.
Can you understand it now clearly? Is it clear?
Yes, ma'am. Thank
Okay,
you.
fine. So this is the concept of how a property is being transferred. Now let's move back to our Bare Act. So the explanation to this uh, section says that living person will also include a company or association or body of individuals, whether incorporated or not. So basically, a company which is a legal person, it has a juristic personality, can also make a transfer. Okay. Also, if a company is incorporated or not incorporated, in both the case, it can make the transfer. Or a body of individual, okay? A body of individuals, say suppose there is a firm which is not a company, but it is a firm which is a body of individual. So a firm can also own a property. So a firm can also transfer a property. But nothing herein contained shall affect any law for the time being enforced relating to transfer of property to or by the companies, association, or bodies of individuals. So basically, this clause says that transfer of property will not affect the law which is enforced for transfer of property by companies or association. So if there is any provision in the Companies Act of 2013 relating to how a property would be transferred by a company, then that provision will be applicable and not the Transfer of Property Act. Okay. So basically, any special law which is there to transfer a property by companies or association or bodies of individual, then that special law will prevail over the general law of transfer of property. Okay. Now, the next important topic is what may be transferred. So till now we have read, we have studied, or we have discussed who may make a transfer. Sorry, how a transfer is made. But now let's read what could be transferred. So section 6 says that property of any kind may be transferred. So any property will be transferred under the provisions of Transfer Property Act except as otherwise provided by this act. So any property can be transferred except the provisions of this act. What exceptions have been provided are excluded. Otherwise, all the other properties could be transferred. Now, what are these exceptions? Let's discuss it one by one. So, as per Section 6, Clause A, the chance of an heir apparent succeeding to an estate, the chance of a relation obtaining a legacy on the death of a kinsman, or any other mere possibility of like nature cannot be transferred. So, basically, it is the transfer of spes successionis, which is the very first topic which we have discussed today. Okay. So, a spes successionis transfer is not allowed to be transferred in under the Transfer of Property Act. Okay. Number 2, a mere right of re-entry for breach of a condition subsequent cannot be transferred to anyone except the owner of the property affected thereby. So if there is any right of re-entry to certain property, so right of re-entry is provided to the owner of property. There should be a property, there should be a owner of the property, and someone would have should have affected the rightful ownership of that person. So say suppose someone has encroached some property and it was in dispute, and afterwards, after the decree of the court, the real owner gets the right of re-entry. Okay. So this right of re-entry cannot be transferred to anyone other than the person who was the owner of the property. Then coming on to the next, an easement cannot be transferred apart from the dominant heritage. So easement is what? Easement is the right which is related to the right of way. So say suppose there is a house. So since you have the house, you are the owner of the house or you are in the possession of that house. Even if you are a tenant to that house, you have the right to way. You have the right or you have the title under the law to have the way to move to your house, right? No one could suppose that you can come flying to your house if there is no way to go to your house. Okay. So that is called as easement. So easement cannot be transferred apart from the dominant heritage. So you cannot transfer the road to someone because road is there to provide way to your property. Okay. So when property will be transferred, only then that particular way to the property will be transferred. It cannot be transferred alone. It cannot be transferred except segregated to the property to which it is attached. Okay, so easement cannot be transferred apart from the property. An interest in property restricted in its enjoyment to the owner personally cannot be transferred by him. So any interest which is there in property, which is only restricted to the enjoyment to the owner personally, that cannot be transferred. So for example, if there is a property which is owned by someone, but the property is not owned by someone, only the right to enjoy that property is owned by someone. Okay, let me give you an example. Suppose there is a land which is owned by government. Okay, the government transfers it to a person or grants the permission to a person to enjoy um to enjoy suppose he can grow some flowers over that property. Okay, so he can only grow some flowers on that property, so that person cannot transfer the land on which he is growing the flowers over it. Okay, he is only the owner of the interest in that property, and that interest is to grow some flowers. So you cannot transfer the land, which is the property, because you are only restricted to the enjoyment of that interest, and that enjoyment is only to the owner personally, because the government has provided the person that only you have the right to grow flowers over this property. So you cannot transfer that, because someone has transferred you to enjoy that property, and he has only transferred to you. He has not given you permission to get it transferred to someone else. So you have to obtain prior permission. Similarly, there are certain other conditions also. For the purpose of examination, just read all these exceptions. Okay, just read all these exceptions, and whenever there will be any question relating to something which where it will be asked that what could not be transferred, then just go to the section. Okay, and find to which clause it relates, and you will find the answer. So since we are running short of the time, we are not going to discuss all the clauses in detail, but just remember that there is section 6 which talks about what may be transferred. So if you find any question where it is asked that what could be transferred from among the following, or what could not be transferred from among the following, okay, then just proceed to section 6 of your BERAT, and you will find the clauses and you will get your answer. Okay, now let's come to the next topic, which is person who are competent to transfer. So first of all, we read what is transfer of property. We read what are the properties which could be transferred, and we also studied what cannot be transferred. Okay, then let us discuss who can transfer. So according to the act, every person who is competent to contract, okay, and every person who is entitled to transferable property. So entitled to transferable property means he should be either owner of the property, he should be lessee of the property or tenant of the property, and he is authorized to transfer to someone. So there is only two clauses which we were discussing before, that he should be either owner or he should be authorized to transfer that property. So in the authorized to transfer the property, there could be agents, there could be tenants, okay, or authorized to dispose of transferable property not his own, or he is the person who is authorized to dispose of transferable property which is not his own, basically the agent, is competent to transfer such property either wholly or in parts, and either absolutely or conditionally in the circumstances, to the extent and in the manner allowed and prescribed by the law for the time being in force. So basically, every person who is competent to contract, that means all the essentials to make a contract are also applicable here. And what are those essentials? That he should be major, he should be of sound mind, he should be able to give his consent, and consent should be free consent. Okay, so that person will be will be the person who is competent to contract. Then he is also competent to transfer. But again, he should be entitled to a transferable property, because we are dealing with transferable properties. So you cannot transfer something which you are not owning. You can have more than one mangoes. You may have 10 mangoes, but at least you should be having one mango to transfer one mango to someone, right? So therefore, you should be a person who is competent to contract, but at the same time, you have to be some entitlement to transferable property. Or if you are not entitled to any transferable property, then at least you should be the person who is authorized to transfer a property which is not your own, which you are not entitled, but due to such authorization of law, you are having the right to dispose that property. So, for example, the court applies. Uh, the court appoints a person to transfer the properties which are seized by the police in the auction. Then that person will be the person who is authorized to dispose of transferable property. Okay. Then that person can transfer that property either wholly or in parts, or either absolutely or conditionally, as per the requirements of the property or as per his rights relating to the property. Okay. If he has the right to transfer all the property, if he is the owner, then he could transfer it absolutely and in whole. And if he is only entitled to half of the property, then he can transfer only the half of property. He cannot make the transfer of whole property. Okay, so depending upon his rights, he can transfer the property. Then section 9, which is very important, it says that a transfer of property may be made without writing in every case in which writing is not expressly required by law. So basically, there could be a oral transfer of property also, but then the law should not have expressly provided that it should be written in writing. So where there in the transfer of property, where it is mentioned that this property has to be transferred only in writing, then their transfer in writing is compulsory. But where it is not expressly required by the law, then you can also make oral transfer also. Okay. Coming on to section 13, which talks about transfer for the benefit of the unborn person. Where on a transfer of property, an interest therein is created for the benefit of a person not in existence at the date of the transfer, subject to a prior interest created by the same transfer, the interest created for the benefit of such person shall not take effect unless it extends to the whole of the remaining interest of the transferor in the property. So basically, section 13 says that where a transfer of property has been for the benefit of some person who is not born yet, then at the then such transfer will only take effect and when it is extended to the whole of the interest of the transferor of the property. Okay. So there should be whole or remaining interest, there should be there of the transferor in the property, and only then it will be effected for the unborn person. Let's see an example of that. So A, there is a person A, he transfers his property of which he is the owner to B. Now B is the person, okay, in trust. Okay, so B is a person who is a trust, and this property is transferred to B for what? For purpose of A, for benefit of A, and A is the unborn, okay, and his intended wife successively for their lives. And after the death of the survivor for the eldest son of the intended marriage for life, and after his death for A's second son, the interest so created for the benefit of the eldest son does not take effect because it does not extend to whole of A's remaining interest in the property. So basically, what it is trying to convey is that the property which is owned by A, which is transferred to B for A and his intended wife success after their lives, okay, and after the death of the survivor. So whoever survives first, so A and his intended wife both have to be both have this property. Sorry, both for the benefit of A and the wife, both for both of the benefits, the property is transferred to B. And what he wants is that it is also transferred to the eldest son of which is born out of the wedlock of A and the wife. Okay, and after the death of eldest son to A's second son. Okay, now both the son have not yet been born. Even the marriage has not been performed. So whatever we are having here is a imaginary situation, is a future situation. The interest also, therefore, the act says that the interest which is created for the benefit of the eldest son will not take effect. Why? Because there is not the interest of A is not completely, because A has transferred the property which is to be shared between A and his wife. Okay, so if there should be only the interest of A, then only the transfer to eldest son of A and his intended wife would be effective. Otherwise, it will not be effective. Why? Because maybe A would survive, or maybe his wife would survive. So if wife is the survivor, then the situation will be different. So therefore, a transfer which is made to unborn person cannot be effective until the whatever remaining interest is there, that is wholly to the person. Okay. Then there is this topic of vested interest under section 19, which says that whereon a transfer of property and interest therein is created in favor of a person without specifying the time when it is to take effect, or in terms specifying that it is to take effect forthwith, or on happening of such an event which must happen, then such interest is vested, unless a contrary intention appears from the terms of the transfer. So basically, vested interest is like contingent contract. So when on the transfer of property, interest is created, which is created in person in the favor of some person, but it does not specify the time that when it will take effect, or it does not or it sometimes provide that it will take effect only upon the happening of some event. Then that interest which is created in that person will be called as vested interest, and that vested interest will only come into existence only the happening of event takes place, or when the time comes into existence. Okay. Then let's move to section 35. It talks about doctrine of election, and section 35 provides where election when necessary. So where a person professes to transfer property which he has no right to transfer, and as part of the same transaction confers any benefits on the owner of the property, then such owner must elect either to confirm such transfer or to dissent from it. And in the latter case, he shall relinquish the benefit so conferred, and the benefit so relinquished shall revert to the transferor or his representative as if it had not been disposed of. Person transfers some property, then after the transfer has been made, uh, also whatever he is transferring has some benefits occurring from it. So whoever gets the property after the transfer, so he should have this option. So he's having this option to elect. So if he confirms the transfer, then he have to pay whatever he should be entitled to pay to the real owner of the property. Okay, when it is found that the person who has transferred to him the property is not the real owner, he has no right to transfer. Otherwise, If he does not want that property, then he can dissent from the transfer. And when he dissents from the transfer, then he should also have to give up on all the benefits which he has been receiving from that property which has been transferred to him by the person who has no right to transfer that property. Also, whatever benefits he has already accrued, that also has to be given back to the transferor. Okay. So this is how we have so these are the topics which are usually asked in the AIB examination. You will not find questions apart from these topics which we have already discussed. But for the matter of we cannot say, we cannot be sure as to only this portion will come, or paper's pattern could not change. So just read the definitions of gift, exchange, and lease. I have mentioned the sections also. So just go to the chapter and just read the definition of lease, exchange, and gift. And that will be sufficient for your AIB examination. Usually 90% of or 95% of questions comes from only these topics which we have already discussed. Now let's discuss these important questions, and this will be all for today. Let me share the tab. Okay, here. So the first question is, the Transfer of Property Act 1882 came into force on. So we have already read the commencement clause in the chapter 1 itself, and it is 1st July 1882. Then immovable property includes. So we have already read the definition where it was said that immovable property does not include growing crop, standing timber, and grass. Therefore, immovable property does not include anything from the list which has been provided here under. So the right answer would be none of the above. Sorry. So the next question is, Transfer of Property Act has no relation with. So transfer of property does not discuss the transfer of air. It does not discuss the transfer of water. It does not discuss transfer of light. So therefore, it does not have any relation with all of these. Next, things embedded in the earth have been included under the transfer property in the definition of. So we have already read that it is the definition of attached to the earth. So we had things embedded in earth, things which are so attached to the earth, or things which are attached to the property which has been embedded in the earth. Then we have the next question, which says that what is not covered by the term transfer of property. So transfer of property includes gift, it includes exchange, it includes lease. You will find in the content list also, there are specific chapters which are relating to gift, exchange, and lease. So transfer of property does not include family settlements. Okay. Because family settlements are dealt under the rules of the laws of succession, which is under the personal laws. Coming on to the next question, it is which is not the immovable property. So we have already seen the definition of immovable property: a lease of land, growing crop, right of way, a life interest in the income of immovable property. So basically, it is somehow repetitive of the question which we have discussed already, and it does not include growing crops because it has been specifically excluded in the definition under section 3. Then next is, which of the following interest is not transferable? I have not marked it because I wanted you to answer it. So we have already discussed what is a vested interest. We have discussed spes successionis, and you will read these two other also. But at the same time, I have told you that in lease is transferable. Okay. Contingent interest is also transferable. So we are left with what is not transferable under section 6 clause A. Anyone? So none of you remembers B. Yes, exactly, Harjot. It is B. because section 6 clause A specifically declines that the space successory transfer cannot be executed under this act. Okay, so the right answer will be this space successoriness. Okay, next is person competent to transfer a property have been defined under which of the section? So it is section 7, which is very clear. To be competent to transfer a property, it is not essential that person to be major. It is essential. Why? Because the essential which has been mentioned under section 7 is that he has to be competent to contract. Next, the person be of sound mind. It is also the condition to be competent to contract. The person is competent to contract. It is specifically mentioned in section 7. So we are left with transferable property is his own, because transferable property could be of someone other and he will be authorized to transfer it. Okay. So this is how we come to the conclusion that the right answer of the question to be competent to transfer property is it is not essential that the transferable property is the person's own property. Okay. So you could see the questions also, the type of questions. These are from the topics which we have already discussed. And these are the questions which I have listed from among 5 years question paper. So only these type of questions comes from the transfer property, and it is very easily doable if you are having the Bear app and if you know what is where in your Bear app. So let me again repeat the tip to read your Bear app. First of all, go through the content page of your Bear Act. Read the illustrations of your Bear Act, because at most, apart from the direct questions from the section, you will find, you may find some illustration and illustration based question. So if you will be if you will be able to understand the illustration, you will be able to do the question. Okay. Then apart from the content, you have to be ready with all the sections which I have provided in the top important topics document from chapter 2. Specifically deal with section 5, 6, 7 and 10. You have to be very clear about these 4 sections. Okay. Then after that, read doctrine of election and also read transfer of immovable property to some extent. Okay. Then just read the definition of sale under section 54. Then section 58 mortgage. Read section 91, which is redemption. And then chapter 5, that is lease. Chapter 6, exchange and gift. Just go through the definition of these 4 topics, because they are not expressly asked. I have not found any questions, but for the sake of convenience, for the sake of you should be precaution, just read the definition from all those 4 topics. Okay. So this is all from my side for today's topic. You may ask any questions if you have any, or you may post it in your WhatsApp group. I will be ready to answer it. And I have shared this document with Paris, and he will be transferring it to you.
Ma'am, shall we end this session now?
Yeah, sure.
Thank you so much, ma'am, for such a wonderful session. Happy learning.
Thank you. Have a nice evening.